So what's not in those rules is this concept of sort of the role of lawyers, which really comes from the model rules of ethics. So the first question that we have to ask when we have an opportunity to incorporate a company is, who is the client? If you're representing a startup company that hasn't been formed yet, what does that mean? Who do you represent? Do you know, John?
When you represent the company, the issue becomes what's your relationship with the individuals who formed the company prior, and how does that carry over?
But the company doesn't exist yet. Until the certificate is filed, the company does not exist, right? The company comes into existence when the Delaware Secretary literally stamps the certificate. That brings the company into existence. So, how do you represent something that doesn't exist? This is metaphysics, right? You thought this was corporations class. It's metaphysics class. Well, the lawyer at this point is said to be the representative of the situation, which is a slightly different concept. That corporation doesn't exist yet, and so at this point, in the pre-incorporation stages, the lawyer represents the situation. Yeah, it's challenging. And what does that mean if there are multiple parties of interest here? So we're going to go through a series of hypotheticals to help flesh this out a little bit. I think that'll be the best way to understand this, through a series of hypotheticals here. Because, as John pointed out, you've got people in the room, but you actually don't represent them. And you have to let them know that. So if you represent the situation, who do you not represent? Tom, Dick, and Harry, right? I mean, you don't represent the people. So there is a distinction there. And you will come to represent that corporation, and that corporation may have interests at odds with the person who hired you. I mean, look at Uber. Travis Kalanick came to a startup company, a firm that I work for, Fenwick & West, with the idea of Uber. He paid the bills, he had the meetings. Eventually, Travis wasn't so good for Uber. Who does Fenwick represent? Uber, not Travis. Now that's hard because you've been talking to Travis for 7 years, and he writes 7-figure checks with your firm's name on it. So, you piss him off, he's probably going to go to another firm, end up not being with the company. There's some real challenges, some real ethical challenges built into this idea of representing the company, because you don't talk to a company, you talk to human beings who come before you, but you don't represent them. And this creates some tensions and some confusion within the client. And I think the Travis Kalanick story is a good one because, eventually it became clear that he wasn't good for that company anymore. So who do you represent? You represent the company. He's going to have to get his own lawyer. You can't represent him. You're conflicted out of that. So I guess a fundamental question is, do people who are acting as a corporation or who are trying to form a corporation, do they know this? Yes?
Does the attorney only get paid then post-incorporation?
That depends how you structure it. Yeah, I mean, I prefer an arrangement, because they're really straightforward once you know what you're doing. So you can have a pretty good estimate on how much time it will take you. So it's nice to be able to just bill up front and then go ahead and perform the services. It avoids collections, and it avoids any messy issues like this. But, if it's a more nuanced situation, or, they think that they can do it quicker or what have you, they may want to negotiate for an hourly arrangement, in which case, yeah, you're going to have to do the work and send them a bill. But there's nothing wrong with doing it as a fixed fee basis and charging in advance, but, it has to do with market conditions. Is your client going to accept that? So do people acting as a corporation know this? Professional ethics rules require the lawyer to communicate this. Model Rule 1.7 says that a lawyer acting in a capacity such as this has to communicate to the parties the advantages and risks of this type of multiple representation. There are other situations where there could be multiple representation as well. Like, for example, a man and woman can come to an office and to try to arbitrate a divorce type proceeding before it goes anywhere. And there can be some challenges in family law with the ability to do that as well. So this is not the only situation in law where you might have multiple representation, and they're always hairy. And the rule is Model Rule 1.7. And whether or not you can do this has to do with some theory. It has to do with whether or not a particular jurisdiction is going to take the aggregate theory of the corporation. what is the difference between the aggregate theory and the entity theory in regards to the situation? What would it mean to have the situation be an aggregate? An aggregate of what? Yeah.
The people that you're doing.
Yeah, exactly. An aggregate of people you're dealing with. And if the situation is an entity, it's one step removed. So if this is an aggregate theory of representation, the lawyer represents both the participants and the corporation. If there is an entity theory, it only is the corporation that's being represented. This is a real fine point of ethical rules, and it tends to be something that gets litigated. So it's something to just be careful about. There's not like a clear answer on this, and different judges, different courts could hold differently, depending on how they see the situation and what the intentions of the parties were.